Okay, this is Grow Michigan LLC versus GSE IAS LLC et al., docket number 20-469CB. I have a Lisa Hall calling in. Is that someone who should be in our meeting, our hearing?
I don't know that name.
Lisa Hall represents Byline Bank, who has filed a notice of interest.
Then I'll let her in. Okay, so backing up a bit, it's docket number 20-469CB, and this is the time set for hearing on a couple of motions. We've got GSE's motion for partial summary disposition of count 1 of the plaintiff's complaint, and motion for summary disposition of MSU's interpleader, and then MSU filed their separate motion for summary disposition. It sounds simple, but at one point I had to draw a schematic diagram to figure out how these all fit together. So unless someone has a real problem with it, I suggest that we just argue them all together as one, if that makes sense. And I'll start with your appearances, though, for the record.
Michael Perry, Your Honor, for Alphine and GSEIAS. Amy Wolanin of our firm is also here with me today.
Good afternoon, Your Honor. Bill Burdett on behalf of the plaintiff, Grow Michigan.
Good afternoon, Your Honor. Scott Chernich on behalf of Michigan State University Federal Credit Union.
Okay. And then I think we have Lisa Hall in the hearing as well, and I was informed, Ms. Hall, that you represent Byline Bank. Is that, although you don't have an appearance in this case, but just to
Yes, Your Honor.
That.
Yes,
Okay,
Your Honor. Lisa Hall on behalf of Byline. We just filed a notice of our interest in the assets of GSE.
Okay, very good. Then we'll proceed, and Mr. Perry, you can go ahead.
Thank you, Your Honor. As the court noted, Alphine and GSEIAS had filed a motion for partial summary disposition of count 1 of Grow's complaint. Count 1 is entitled interpleader. And we had filed a motion, included within that, a motion for summary disposition of the credit union's interpleader claim. Kind of working backwards, the motion with regard to the credit union's interpleader is essentially moot, I would think, because a couple weeks ago the court allowed the credit union to deposit the money at issue into the court, although an issue regarding the discharge of the credit union's liability remains outstanding. But in terms of the basic interpleader issue, as far as MSU is concerned, I think that's history in light of the court.
So can I ask you something? Because this is what was so confusing.
Yes.
So does that mean that we don't have to address your arguments about how you claim plaintiff doesn't have any legally cognizable interest in the funds? Because that argument went to MSU's interpleader.
Well, it went to two things, Your Honor. It did go to the interpleader because I was arguing that you should simply release the funds to my client, and we didn't need an interpleader, but the court allowed for the deposit. So we still have the issue about Grow's interest because the court now has the money. So I'm going to address Grow's interest or lack thereof. In our motion, we pointed out a number of problems essentially with Grow's position with its count 1. First principal problem is the court previously has denied or had denied Grow's motion to direct interpleader. And during the course of the court's ruling, the court, as I recall, essentially said, although we don't have a document that says this, that Grow seemed to be, and apparently was, seeking a prejudgment writ of attachment, contrary to Michigan law. And so we include that within our brief, and we would ask on its face alone, that is reason enough to find why Grove's interpleader claim should be dismissed. Secondly, the court has already denied Grove's motion, so I think that Grove's interpleader claim is moot. We asked counsel for Grove to stipulate to dismiss count 1. Never had a response, so that's why we filed the motion. And in response to the motion, Grove asserts that its interpleader claim is not moot, but doesn't say how or why it's not moot. I would think, in light of the fact that Mr. Chernich has already paid the money to the court, any claim that Grove might have for an interpleader is clearly moot. Or if there's some other legal description here, there's really no need for count 1 of Grove's complaint. To the extent that Grove is claiming an interest in the money at issue, as we pointed out in our brief, there are a number of deficiencies with Grove's claim in that regard, apart from what I've already talked about. Number 1, Grove, on information and belief, asserts that there was a transfer of what I call machining, GSE, fabrication and machining. So we call it machining for purposes of a shorthand reference here, that there was a transfer of machining's assets in question here, the intangibles, to my client, and that my client used those assets to generate the job that it did for Elfing, in turn generate the $108,000. So Grove has asserted this on information and belief. And it asserted that back in September or so when it filed its lawsuit. We're now in the 3rd week, or approaching the end of the 2nd week of November. We've yet to see any evidence from Grove in support of its claim. We have filed an affidavit of Marissa Emfield, who has attested to the fact that GSE IAS has not received, by transfer or otherwise, any assets from machining, has not used any such assets, did not use those to obtain the job with Elfing or to do the job for Elfing. And that remains unrebutted as of this second. So there's no factual predicate for Grove's claim. Additionally, to the extent Grove is claiming that the money, hypothetically, even if there was a transfer and a use of assets, and that the $108,000 was generated thereby, which it wasn't, but hypothetically, that money is not, quote, proceeds within Michigan's definition in the Uniform Commercial Code of the word proceeds. We've provided the court with reference to the statute. There's no Michigan appellate decision on point. We've provided the court with a Sixth Circuit opinion rising out of the Tennessee version of the UCC, which is very akin to Michigan's, where the Sixth Circuit found that the, quote, use of an asset was not a money derived from the use of an asset, was not a proceeds within the meaning of the Uniform Commercial Code. And we would ask the court to apply that principle to this action as well, and find that even if this money hypothetically was derived as Grove claims, it's not proceeds to which Grove would be entitled. And then last but not least, we have Ms. Hall here on behalf of Byline Bank, which last night filed its statement of interest, indicating that Byline has first priority on any such proceeds from the use of the collateral at issue. We argued that previously in our brief, I think on, if I can read my notes, page 4 of my statement of facts and page 13 of the brief, made the point that Grove is in second position regarding these monies. So it has no present claim to these monies regardless, given its lack of position or lack of priority. So for all of these reasons, we asked the court to find that Grove has no viable interest in the money that apparently is now sitting in the court, and we would ask the court to release the funds to GSE IAS as the assignee of Alfing. Would the court like me to move to my motion with regard to the credit union's interpleader claim?
I think you should. Let's just get it all together.
Okay, thank you. The motion with regard to the credit union's interpleader claim, which essentially is moot in light of prior ruling, again, pertained to the lack of interest that GROW has in the asset, and that there was really only one party entitled to receive the money, which is my client. So we argued that really there was no need for an interpleader and that the court should simply release the funds. We've kind of crossed that bridge, so to speak. And then we have MSU's, the credit union's summary disposition. I could certainly respond to that, or I could address that now.
Yeah, I mean, well, I guess that's their separate motion, so I'll circle back to you, okay?
Thank you. So, so the gist of the motion with regard to MSU's interpleader was that it was unnecessary, that GROW has no interest in the asset, and since there was really only one true viable claimant, not two or more as required by the interpleader rule, interpleader was unnecessary.
Okay, thank you.
Thank you.
Mr. Burdett?
Thank you, Your Honor. I find it interesting that at this early pleading position of this case, where we're only really sorting out the parties and where the money is, and Your Honor had to create a schematic diagram in order to figure out what are relatively simple motions. GSEIAS seems to be able to take the position that there's no possible way that these facts could somehow come to light with more discovery. No possible way except for the fact that Marissa Emfield's husband, Joseph Emfield, was a guarantor of old GSE's debt. That Marissa Emfield's new company, GSEIAS, says to Alfing, please send all of your money to my house that I share with my husband, Joseph Emfield, because that's our new accounting department. And that we will use on our invoice the address for old GSE's manufacturing facilities. To say that there are not facts that say this smells, that someone is trying to do an end run around the debt that they owe, is absurd. The fact is that there is general intangibles that were pledged. That pledge includes things like goodwill. And there is no way that GSEIAS, and this is GROW's position, could have successfully bid on work that was begun at old GSE, because old GSE has admitted that they were pursuing work from Alfing. And then all of a sudden, there is a purchase order and invoice issued to Alfing from new GSE that says, hey, we'll do that work for you, because we can. Just send the money to our old address. That should be enough of a fact issue right there to say that this motion should be dismissed and denied. Because the fact of the matter is there's a real question as to who's got the entitlement to this money. And in looking at the first source bank that Mr. Perry talked about, that case from the Sixth Circuit on the proceeds, the fact of the matter is that this is something that would be subject and is part of the dispute, because it's not whether or not that it's subject to our security interest as much as it is MSU FCU credit union is subject to liability one way or the other. That's the whole point of the interpleader. They say we are a financial institution, we are holding this money. GROW Michigan says you have an obligation to give that to us. Alfing says you have an obligation to return that in order to avoid liability for MSU FCU. They did the right thing and come to the court and said, let's deposit it with the court. And we started this with our interpleader action, and certainly I think that it was appropriately filed. My only concern about stipulating to whether or not it should be dismissed is whether or not it would have an effect on MSU FCU's ability to interplead the money with the court. Because ultimately that's what we wanted to do, is to say, while there is a dispute going on, while there is a legitimate dispute going on about who should get this money, it shouldn't go back to Alfing or be passed on, because it could potentially cause some liability for MSU FCU. in the credit union that shouldn't otherwise face liability in this action. So, we feel like that the interpleader claim was properly filed, and I don't think that it's, while I can understand Mr. Perry's argument about whether or not that claim one is moot or not, our only concern would be any dismissal wouldn't be prejudice the interpleader and the filing of that with, the money with the court and the deposit of it with the court. But with regard to the C-10 motion on the claim, I find it also very interesting that Mr. Perry relies on an agreement between old GSE and Byline Bank to say somehow that prevents our recovery against new GSE. That our action in trying to claim this money from Alfing, if it were subject to Byline's interest whatsoever, then it necessarily is an asset of old GSE, not new GSE, not Mr. Perry's client. And I would also point out that the security agreement between Grow Michigan and Byline Bank doesn't mean that Grow Michigan loses its claim to pursue anything against old GSE, new GSE, or any entity whatsoever. The fact of the matter is that my client has a debt that is owed by old GSE. We believe that debt should be passed on to new GSE because they're the same entity. It's just a different attempt to do an end run around our loan and our security agreements. But if Byline were to say, hey, Grow Michigan, if you get any money out of this, you have to follow the security agreement. Grow Michigan at that point will review the security agreement and deal with Byline Bank. But that doesn't mean that we can't pursue GSE in whatever format it takes. It only means that we have to deal with Byline Bank should we get money out of this situation. But there's nothing in there that says we can't pursue this action in any way, shape, or form. So then it just gets down to whether or not these are proceeds that should be subject to our security interest or should be subject to our dispute here. And I think the fact is we haven't done discovery yet. Discovery, this case is as new as they come. And, we certainly intend to be pursuing discovery about, how this bid came to be with Alfing, the conversations between Alfing and Joseph M. Field or Alfing and Marissa M. Field to see how this all came together. There is a lot of facts that need to be unearthed, but there are facts that we know today that, this isn't someone else completely unrelated to the M. Field family. This is a husband and wife saying, well, husband, you owe this debt, but wife, why don't you go get that business so maybe we can get some money out of this? And then we won't have to pay Grow Michigan because we're a totally new company. We just use the same name and the same addresses in order to do the same work that we were doing before. That can't be a basis for a dismissal under C-10 at this stage of these kind of cases. Thank you, Your Honor.
Thank you. And now I'll turn to you, Mr. Chernich.
Thank you, Your Honor. I'll just limit my remarks to the interpleader action right now. I think we've teed up our motion for summary disposition with respect to Alfing and or GSE-IAC's complaint. In this regard, I think that we described to the court before that MSU Federal Credit Union is in the classic no-win situation. We're caught in the middle. We're caught in the middle between Alfing wiring monies to GSE Oldco's account, and then wishing its return, and at the same time having an intercreditor agreement between MSU Credit Union and Grow Michigan. And that intercreditor agreement created a fiduciary duty upon MSU Federal Credit Union that required us to inform Grow the moment any monies hit Grow's account. I'm sorry, GSE's account. I'm getting confused with the parties. I need that diagram. So the moment it hit the account, we had an obligation to tell Grow that GSE's account had a deposit of $108,000. At that moment, maybe a couple of days went by, Grow instructed MSU Federal Credit Union not to return the monies to Alfing, ergo causing us to ultimately file our interpleader, which in fact, we did deposit the monies with the court some weeks ago.
I think you should go right ahead with your argument about the counter cross claim, because then I'm going to turn to Mr. Perry for a response and rebuttal to everything you've said, and Mr. Burdett after that. So,
okay.
And I'm going to rule on them all at once. So.
Okay. All right. Thank you. Well, so important to that, and I'll just cut to the chase. First, I think the issue's been well briefed. The issue that sticks out right now is that the conversion claim is a conversion claim for money. That conversion claim for money necessarily requires that it be pled that there was a fiduciary relationship between Alfing and or GSE IAC and MSU Federal Credit Union. That's not been pled in any form or fashion, and they cannot prove that. What happened here is that Alfing, on its own accord, wired monies to MSU Federal Credit Union. That Alfing Corporation is not in any form or fashion a member of MSU Federal Credit Union. It doesn't have an account at MSU Federal Credit Union. We have no contractual obligation to Alfing Corporation or GSE IAC. So by definition, there's no way we could have a fiduciary relationship to Alfing. Without that fiduciary relationship, either demonstrated or pled, neither of which has happened, there cannot be a conversion claim of money against MSU Federal Credit Union. And that's the crux of it. I will say that the cases that we cited are all after 1990. So all of those cases requiring the fiduciary relationship are binding on this court. I will just back up to one other issue, and that is that the Assumpsit claim that was brought by Alfing is clearly something not cognizable under Michigan law. We briefed the issue to the court, and so I'll rely on our representations in the brief. And then lastly, the unjust enrichment claim all sort of feeds together here in terms of the facts. MSU Federal Credit Union has not been enriched in any way. In fact, quite opposite. We've been put to expend significant amounts of money in defending MSU Credit Union against an unenforceable conversion claim and a claim of Assumpsit that doesn't exist under Michigan law. And so there's no way that it could be construed in any way to say that MSU Federal Credit Union has been enriched in any way by the deposit of this or by the wiring of these monies to GSE's account.
Okay, so this is why it was so complicated. So Mr. Perry, if you want to do rebuttal argument on what Mr. Burdette has said about your motion and also respond to Mr. Chernich's.
I will. Thank you, Your Honor. And of course, as counsel pointed out, we have briefed this. I think each party's probably submitted 2 or 3 briefs here, but I will be equally a quote brief in my remarks for that reason. Mr. Burdette's statements about the questions of fact pertaining to 2 of his counts in his complaint about a successor liability claim, and there's some other related claim, continuing enterprise claim or something. Those remarks, in fact, demonstrate why it's inappropriate to tie up my client's asset pending resolution of those issues. This court has had hundreds of liability disputes in many, many circumstances throughout the court's career. I'm going to guess that in 99+% or more of those cases, the court has not required a defendant to place an asset with the court or required a defendant not to use one of its assets pending the outcome of the litigation, barring some emergency circumstance or something that might give rise to, for example, a prejudgment writ of attachment, where the attachment was necessary to secure jurisdiction over the party. As in any liability dispute, plaintiff versus defendant, regardless, breach of contract, trade secret, use of a company's recipes because they're trade secrets. A claim like this, continuing enterprise, successor liability, allegations, they're all allegations. Courts do not restrain or prohibit one from using one's asset in light of allegations. And so I would suggest that Grove's arguments here today buttress our argument that it's wholly inappropriate to tie up this asset. Everybody in this courtroom and on this screen today knows that the money belongs to Elfing, knows that Elfing mistakenly sent it to the credit union, that Elfing, through its bank, PNC, requested the money to come back. So everybody here today, and since this case got started in September, everybody in this room knows that the money belongs to Elfing. Mr. Burdett, Grove, through Mr. Burdett's firm, has no claim against Elfing. So Elfing is the innocent party in this proceeding. There's no claim against Elfing. Elfing wants its money back. Now, Elfing, as we've told the court, has assigned its interest in that money to my client, but it is Elfing's money and the money should go to Elfing. And Grove has not said anything today or in any of its written papers to date that would suggest any viable, legally cognizable reason why the money should not go back to Elfing. And so we would ask that to occur regardless of what happens with the claim with the credit union. That's separate and apart from now what's going to happen to this money. So what should happen with this money is it should go back to Elfing.
Okay, thank you. I might have misspoke because Mr. Burdett, you already had a response to Mr. Perry's argument, but again, this was so confusing with the briefing. Do you want any more rebuttal time to what he's just said?
I would only, very briefly, Your Honor, just point out that 99% of the cases that have probably come before this court, you didn't have a situation where a husband was a debtor on a previous debt and the wife opened up the same company, a couple months later to do the same work of the husband's company. That is a fact situation that you just don't see all the time. And that's why Grow Michigan takes this so seriously about the disposition of these funds, because they're clearly being used to pay down debts that should be attributed to the old company because it's the same enterprise.
Okay, thank you. Did I cover everyone?
Yes, Your Honor.
Insofar as Grow is concerned, you have.
Okay, thank you. Then I will start first of all with GSE's motion asking for dismissal of count one of the plaintiff's complaint. That's the easiest one of this batch, and that's the interpleader claim. And I would grant that for the same reason that I denied the plaintiff's motion, emergency motion for interpleader, and that is the plaintiff doesn't satisfy the interpleader requirements. The complaint does not allege the sufficient components of interpleader. The plaintiff didn't possess the asset at issue. There's no allegation that plaintiff has any liability to anyone. And so that is granted and count one of plaintiff's complaint is dismissed. That takes us to the next step, which is this is GSE's argument that there's no genuine issue of material fact, that plaintiff has no legally cognizable interest in the funds, and therefore GSE / Elfing says the money should be returned to it. The first issue is this issue about the verified complaint versus the affidavit of Marissa Emfield. And this is GSE's argument that none of this is true. The collateral wasn't transferred to GSE IAS, and IAS did not use those assets to obtain work from Elfing. And they've suggested that the affidavit of Marissa M. Field with personal knowledge trumps what's in the plaintiff's verified complaint. I don't even know why we're talking about the allegations in the complaint versus the affidavit saying that it didn't happen, because this is a C-10 motion. Discovery, I think maybe I read in one of the many briefs that maybe some discovery has taken place, but the case is like 2 months old. We haven't even, I don't think we've even had a scheduling conference yet. There's no, if discovery's begun at all, it's hardly begun. The allegations in the complaint are well pled, and they provide an abundance of allegations based on circumstantial evidence. I wouldn't necessarily apply Mr. Burdett's proposed legal standard of this smells, but I think that I could at least say that there are an abundance of genuine issues of material fact. There is no comparison between this situation and the one in Miller versus Rondo, R-O-N-D-E-A-U, where an affidavit of meritorious defense was required. So I don't see any basis at all for saying that somehow a complaint, a verified complaint based on information and belief can get thrown out or disregarded or adjudicated when the other side files an affidavit of personal knowledge saying that none of this happened. Information and belief is just fine, and the plaintiff has a right to develop further information through discovery. I'm certainly not going to rule that essentially everything in the plaintiff's complaint is untrue just because an affidavit denies everything, not at this stage and not in this context. Now, do I usually keep somebody's asset? Does the court keep it while a dispute like this is going on? Well, no, but this is a situation, as Mr. Burdett has described, where that is justified, and we had interpleader, by MSU-FCU for the very reason that there's a dispute over who this money belongs to. Yes, the court does keep funds on deposit when there's a legitimate dispute over who the money belongs to. GSE's argument presupposes that it's GSE's asset, and I can't presuppose that given the allegations in the complaint and the early stage of this case. The next argument that GSE makes is that even if the funds arose from use of the collateral, only funds from the disposition of collateral are proceeds to which a creditor's security interest applies. And of course, that's based on the definition of proceeds in the UCC. But the plaintiff never used the word use, at least in my reading of the complaint, as a term of art or a defined term from anything. The complaint's broad enough in its allegations that the collateral was used to allow for further discovery to reveal whether the use, so-called use, involved the sale, lease, license, exchange, or other disposition of collateral, which is the definition taken from the UCC. So I reject that argument as well. And then the third issue that was raised in this regard by GSE is that the plaintiff's interest is secondary to the lien of Byline Bank anyway. Now, I must confess, that one had me scratching my head, and I was prepared to ask a rhetorical only question, is Byline Bank a necessary party? And again, that would have been rhetorical, and now I realize there's been a development with respect to Byline Bank. But in any event, that's not a reason. I mean, GSA makes the point that Byline Bank has a superior interest, but that's not a reason to order the money paid back to GSE. That's a reason to keep the funds on deposit with the court until discovery takes place and there's some resolution of the issue of whether the funds are subject to, I guess we could say, any security interest, or whether the funds should in fact be returned to GSE. And in any event, plaintiff makes the point, and it's a well-made point, that even if that is the case about Byline Bank, it certainly doesn't mean that the plaintiff can't pursue this action. So for all of those reasons, I am granting in part, denying in part, GSE's motion for partial summary disposition. And that takes me to MSU-FCU's motion, where they are asking for dismissal under C10 of all of GSE's claims against MSU-FCU in its counter cross-claim, and also for disposition of MSU-FCU's interpleader complaint, where it would be dismissed and MSU discharged. And in that regard, we of course have an issue about conversion, because that is what the claims are, or one of the three claims, in GSE's counter cross claim. And that's exactly why there's a schematic drawing on my desk for all of this. So, but it does boil down to, in main part, whether there is a valid conversion claim. And of course, Aroma Wines is a leading case regarding conversion, but Aroma Wines involve personal property, not money. The rule of law when the conversion involves money is that the defendant must have an obligation to return the specific money entrusted to his care. Merely possessing someone else's money is not enough. There has to be an independent trust or fiduciary duty to return the money. And here I have to stop and address some of the cases that the sides have briefed. First of all, we've got Check Reporting Services versus Michigan National Bank. GSE thinks that means something in its favor, but that case actually states the rule that requires, when it's a case of money, the money has to be entrusted to another's care. And that case really is, it's of course valid for that rule, but it's not applicable to anything else in this case, because the Court of Appeals held in that case that dismissal of the conversion claim was proper because the bank had a right to the money. So what that case gives us is an affirmation of the rule when you have a conversion claim involving money. The next case is Department of Agriculture versus Apple Tree Marketing, but the distributor in that case who possessed the funds had the role of statutory trustee over the funds. So that also does not support GSE's position. And although the court stated that the rule of conversion, the court stated in that case the rule regarding conversion of personal property, not money, but I think it's sort of irrelevant because, again, there's no holding an apple tree that's applicable here. It was about whether an agricultural development kind of statute, I forget what it was called, abrogated a conversion claim. So, but they did apply conversion to, in a case involving funds, where the person holding the funds was a statutory trustee over the funds. So that's perfectly consistent with the rule and it requiring that for conversion of money. And then we've got the case that, and I don't mean this to be critical, but in case this is reviewed by the next higher court or anything, the case that everyone calls Hausman, Hausman versus Imlay City State Bank. That's not what the name of the case is. It's Hansman, Hansman versus Imlay City State Bank, and it's not, and this is how I discovered that, it's not at 121 Mishap 414. It's at, just for the record, it's at 121 Mishap 424. But in any event, the total Sum total analysis of the conversion claim in that case was as follows. Any distinct act of dominion wrongfully exercised over another's personal property constitutes conversion and intentional tort. Thus, plaintiff's complaint also stated a cause of action for conversion. We conclude that summary judgment was improperly granted. That statement, by its very language, is a statement of the rule of law regarding personal property. It's not the rule that's stated in later cases regarding conversion of money. It's also not a very complete analysis, was my point, about the conversion in that case. But in any event, this incorrect statement of law regarding money is of no consequence to this court because Hansman was decided before November 1 of 1990, and it's not binding. So GSE points out factual differences in several other cases. There are factual differences in other cases from this case, but the rule of law is always stated the same. And that is when it comes to conversion of money, just possessing it and refusing to turn it over is insufficient. There has to be entrustment of specific money and some sort of duty in the form of a trust or fiduciary duty to turn the money over. There is no factual dispute here that Elfing was not entrusting money, was not entrusting money to MSU FCU. Affling, whatever they are, mistakenly sent the money to MSU FCU. MSU FCU wasn't holding the money in trust or with any fiduciary relationship to Elfing or GSE. There is a party for whom it could be said they were holding the money in trust, but that party would have been plaintiff under the subordination and intercreditor agreement. But this has nothing to do with any claim by plaintiff under that agreement, and there is no claim by plaintiff under that agreement. This is GSE Elfing's claim for conversion against MSU FCU, and as a claim for conversion of money under the undisputed facts, it fails as a matter of law. And then the writ of assumpsit, I think we've all agreed that's pretty much been abrogated. It wouldn't apply anyway because the money's on deposit with the court. Unjust enrichment also has particular requirements in this case, and to the extent that MSU FCU was even enriched by holding the funds for, 3 months before depositing it with them with the court. There are no allegations in the counter-cross claim, and there will never be any facts to support that MSU FCU didn't request that it receive these funds, and it didn't do anything to mislead anyone. So I'm granting summary disposition as to all the claims in the counter-cross claim against MSU FCU. The counter-cross claim is dismissed, and the interpleader is dismissed, and MSU is discharged under the court rule from liability in this action. So MSU will no longer be a party to this action. And I think that Mr. Chernich is probably going to have to submit an order on that, and Mr. Burdette is probably going to have to submit an order on the other, being the prevailing party mostly.
Understood, Your Honor.
Sound
Thank
good?
you, Your Honor. Yes, Your Honor, thank you.
Okay, thank you.
Thank you.
Thank you, Your Honor.